Hello and welcome to a pre-recorded only session of our regular Business Swansea Power Hour workshops. Now, as you'll be aware, normally we have these as live open sessions that guests can book onto, allowing them to ask questions and join in a wider discussion. However, given the potentially slightly sensitive nature of this topic, we've taken the decision to have it as a pre-recorded YouTube only session. The format will run as normal. It'll be a short presentation with myself and Steve then asking some questions, picking up some of the key discussion points. If you have any questions you'd like to ask the presenter, there'll be contact details available at the end. This is a really important topic, and whilst maybe it's not as fun and engaging as some of the other topics that we run on topics like social media, it is nonetheless really vitally important. If you do find yourself in this position, very likely through no fault of your own, it's important that you put the right procedures and the right mechanisms in place. This will be a regular session in terms of its length, and then contact details will be available to engage with our guest speaker at the end. Thanks for watching.
So this talk is in relation to insolvency, and the subject being spotting the warning signs and knowing what to do in those circumstances. Who am I? I'm a solicitor with W Parry Co solicitors here in Swansea. I've been practicing as a solicitor for 25 years, dealing with all aspects of civil and commercial litigation, including insolvency matters. And I'm also a licensed insolvency practitioner with BPO Insolvency Limited, having qualified in 2018. So what is an insolvency practitioner, and what does an insolvency practitioner do? An insolvency practitioner is a person who is licensed, which means authorized by the government, to take action regarding the financial affairs of an insolvent business. Only a licensed insolvency practitioner can take formal insolvency appointments, and there are approximately 1,500 licensed insolvency practitioners in the UK. Most IPs are accountants, and one or two of us are solicitors. Most IPs will look to rescue or turn around a distressed solvent business, either by entering into an agreement with creditors to pay back debts over time, to sell assets, or to enter into administration. If that's not possible, it's not possible to rescue the business, then an insolvency practitioner will work to maximize creditor interests, typically by ceasing trade, placing the company into liquidation, and converting its assets into cash to distribute amongst creditors. I thought it would be helpful to look at the current financial position in the UK. We're all aware of this from the news and so on. No surprises, therefore, for anyone listening, but it is a very difficult time to be in business. And for that reason, business owners need to be extremely vigilant and careful regarding their businesses. Looking at the pre-2020 COVID and lockdown period, financial circumstances at that time were already difficult, and arguably in areas such as South Wales, we were still suffering the effects of the 2008 world financial crisis. There were a high number of zombie companies, that is indebted businesses, which, although were generating cash following payment of their running costs such as wages, rents, etc., they only had enough to service interest on loans, but not the debt itself, and so were in fact a step away from insolvency. Then, of course, in 2020 we had COVID and lockdown. And in relation to insolvency, the government did several things which halted insolvencies. The government introduced temporary measures under the Corporate Insolvency and Governance Act of 2020, CIGA, which more or less prevented bankruptcy and winding up petitions from being presented, and also suspended wrongful trading. However, those measures were ceased on the 31st March 2022. At which point there was a return to the usual insolvency regime. Secondly, as we know, during COVID, there was significant support for businesses from the government in the form of grants, furloughing, and bounce back loans. They have, of course, fallen away, and without such assistance, businesses now find themselves in a position of having to stand on their own 2 feet again, and having to repay bounce back loans and so on. Adding further to the gloomy picture, the autumn budget of 2022 forecast that household disposable income in the UK would fall by 4.3% in the financial year of 22-23, which is the biggest fall in living standards since records began in 1950. We have high inflation, of course, and we have increasing interest rates. As of yesterday, increased to 4% by the Bank of England. We also have a cost of living crisis, with 92% of UK households saying that their cost of living has increased. Added to that, we have the war in Ukraine, which has significantly increased fuel prices, and all of this has led to less consumer spending, which obviously affects businesses. And the double whammy is that whilst businesses are seeing less consumer spending, the businesses themselves are also having to meet increased costs for fuel and other services. And the Bank of England has recently stated that the UK will enter into recession this year. As to the increasing number of insolvencies, you'll see on the following slides graphs produced by the government, from which you'll see a decrease actually in bankruptcies post-COVID, but that's probably due to an increase in the number of debt relief orders and IVAs, individual voluntary arrangements. And in relation to companies, you will see a steady increase in relation to compulsory liquidations, that is, liquidations ordered by the court, and quite a significant increase in voluntary liquidations and company insolvencies generally. So the picture overall is far from rosy, and I say that not with a view to being some sort of doom monger, but rather to emphasise the need for business owners to be pretty much on high alert regarding their business affairs, and to act quickly and appropriately should any of the warning signs arise, which I will come on to later. I thought it would be helpful just to run through the types of business structures with a view to giving the insolvency bent in relation to those. Most people will be familiar with the four main business structures in the UK, but just as a reminder, they are firstly sole trader, this being a business formed and operated by one person, so the person is operating on their own account. And the important point to note here, as far as insolvency is concerned, is that there is no separation between the person's business affairs and their private financial affairs. So, for example, if they owe business debts and as a result of such they were to become bankrupt, their personal assets, such as their home, would become available for their creditors to repay those business debts. Then we have partnerships. A partnership is similar to a sole trader business. However, the person forms and operates the business with one or more other persons. But again, from an insolvency perspective, there is no separation between the partner's business affairs and their personal financial affairs, and so the entirety of the business and their personal business and personal assets and liabilities are taken as a whole, and they are not considered separately. So to avoid the personal risks associated with sole traderships and partnerships, many people operate their businesses through a limited company, which provides them with limited liability. They also do so for tax reasons. These businesses are registered at the company's house. The company is a legal entity in its own right. That means that should the company become insolvent, then the owners, i.e. the shareholders and directors, personal financial affairs are not taken into account, and there is no liability to the shareholders and directors unless they've acted in certain ways in relation to the company, which means they lose the benefits of their limited liability status, and I'll talk a little bit about that later on. And then we have, fourthly, limited liability partnerships, or LLPs. These are not as common as the others. They're similar to general partnerships. However, the partners are not personally liable for the debts of the business, and LLPs are normally restricted to professions such as lawyers, accountants, and GPs. Then moving on, and what is insolvency? In simple terms, insolvency is a term for a situation where an individual or a company can no longer meet their financial obligations to their creditors, i.e. the people they owe money to. On a more technical and legal basis, Section 123 of the Insolvency Act of 1986 provides a test for insolvency, or rather a definition, of when a company is unable to pay its debts. And it's this test or definition which a judge would apply should there be a question in court as to whether or not a company is insolvent. And it's the same test that an insolvency practitioner will apply when meeting with a client to consider the financial position of a company. So under the test, a company is deemed to be insolvent if A, a creditor to whom a company is indebted for a sum exceeding £750 has served on the company a statutory demand requiring the company to pay the debt. The company has 18 days to pay the debt or to compound security for it, which means offering acceptable security, failing which the creditor can apply to the court to wind up the company. In fact, the creditor can apply to petition the court without serving a statutory demand, but the creditor would have to prove to the satisfaction of the court that the company was unable to pay its debts, whereas an unsatisfied statutory demand proves such. Then B, there has been an execution, which means a bailiff has attended the company's premises to enforce judgment, and that execution has been unsuccessful or unsatisfied. C, it's proved to the satisfaction of the court that the company is unable to pay its debts as they fall due, which creditors tend not to try to establish this because it's so difficult to do so, and instead they tend to rely upon an unsatisfied statutory demand. Secondly, a company is deemed to be unable to pay its debts as they fall due by reference to the value of its assets being less than the amount of its liabilities. And this is known as the balance sheet test. And this is what the company's own accountants usually see and identify as the insolvency of a company. And again, it's the same test that the insolvency practitioner would apply at a meeting with a client to assess the solvency of a company. Just to note, in relation to individuals, there is a similar test under Section 268 of the Insolvency Act. An insolvency is where there has been A, an unsatisfied statutory demand, or B, an unsatisfied execution process, i.e. bailiff has come away empty-handed. So moving on then to the warning signs of insolvency, and these are the typical ones we see. The warning signs are many and varied, but these are the usual ones. Firstly, the business accountant or bookkeeper will advise that the accounts have been prepared and that the news is not good, i.e. that on a balance sheet basis the business is insolvent, or that there is some other accountancy indicator which suggests insolvency. There are a couple of difficulties with this. Firstly, the news often comes too late. The accounts are prepared many months after the financial year, and so the problems are long-standing, and all the times the accountant or bookkeeper is preparing documentation relating to the financial position of the company and doesn't want to deliver bad news to the business owners, and so delays from doing so. And on this point regarding accountants and bookkeepers, as a point of advice, you should avoid leaving matters solely to the accountant or bookkeeper. A business owner should have a full and complete understanding of the financial position of the business. They should have available to them all financial documentation important to the business, such as cash flow forecasts, aged debtor reports, bank reconciliations, sales forecasts, etc., so that they can identify the warning signs and possible insolvency of the business. Secondly, the business has received a statutory demand, as we referred to before, a formal demand served on the business by a creditor who's owed at least £750 if it's a company, or £5,000 if it's an individual. There is an 18-day period in which to either pay the debt or compound security for it, and stating the obvious, it certainly shouldn't be ignored. It's a serious document. If the business does intend to pay it, the business should ask itself what the effect of paying or meeting the statutory demand will be on the business. Will it put increased pressure on the business elsewhere? Is it pushing off the financial problem to another date with another creditor? And so it's often best to get advice in relation to a statutory demand before paying it. Thirdly, where a statutory demand has been ignored or not dealt with, has the company been served with a winding up petition, or has an individual, a sole trader or partnership been served with a bankruptcy petition? Four, have threatening letters, emails or telephone calls been received from suppliers or other creditors? It's human nature to ignore these things, both as individuals and businesses, but the earlier they're dealt with, the better, rather than allow a frustrated creditor rank up the pressure and take further action. Fifthly, county court claims have been received or county court judgments have been obtained against the business. Excuse me. As the statutory demand, if such have been received, then before such claims or judgments are met, the business should consider the impact of paying, what the impact of paying them would be on the business generally. Is it just going to defer to another day, the difficult decision which might need to be taken in relation to the insolvency of the business? As a solicitor, I've had plenty of occasions when I've been consulted by a client as to whether they have a meritorious defence in relation to a claim. And then ultimately, in the discussion, it's become apparent that the company has other debts, which are significant, and solving this one debt issue will not solve the other problems in the business, and a wider view needs to be taken in relation to the business and its solvency. 6, the landlord, if the company or business has a rented premises, has distrained, which means that the landlord has taken walking possession or even actual possession of assets in respect of unpaid rent. 7, there have been bailiff visits in respect of unpaid debts, judgments, or HMRC unpaid taxes. 8, there have been bounce checks. There have been return standing orders, or there have been non-paid direct debits. 9, there has been contact from HMRC regarding unpaid taxes, whether that's letters, statutory demands, bankruptcy petitions, or winding up petitions. 10, hire purchase or lease companies have repossessed vehicles or equipment. 11, there is difficulty with cash flow. The business regularly struggles to meet payments such as wages, energy, bills, business rates, or on a more general basis, the business continually has cash flow problems, i.e. it's spending more than it earns. 12, the business has maximised its borrowing, so it's reached or it's nearing its overdraft facility limit, or it's unable to obtain loans or other capital investment. 13, banks insist upon high interest payments, which could indicate that the banks regard the business as being in poor financial health, or it's a high risk. 14, extended debtor or creditor days. So either the business is not receiving payments from customers within a required time frame, and those are not being pursued for some reason, or the business is not paying its creditors and suppliers within the usual time frame. These are things, if these things are becoming a pattern and a habit, then it's a warning sign. 15, similar to the above, there's a large customer debt, perhaps on a fulfilled contract. It's not been received, it's important to the business, but there are rumblings or murmurings that perhaps it will not be collectible. If that's going to impact on the survival of the business, then it needs to be addressed and should be considered as a warning sign. And then finally on this list, falling margins. The saying goes, turnover is vanity, profit is sanity. So looking at the profits rather than sales, bearing in mind increasing costs to the business, which we mentioned before. Are the profit margins falling? Have they been falling for some time? If so, this could be a potential warning sign of insolvency or pending insolvency. Then failing to heed the warning signs and to act. So what would happen to the business potentially, and or the individuals of the business if they failed to act or to act quickly? So this depends on the business structure. For a sole trader, the risks to the sole trader of failing to act is that the matter is taken out of their hands. They could have judgment entered against them. This could result in creditor pressure to them, which is distressing for them. It could result in bailiff visits. Their personal credit rating can be affected. Charges can be placed on their property, any properties they own, including their homes. And the most severe consequence to them is potential bankruptcy. And if they are declared bankrupt, then all of their assets, both personal and business, including their home, if it's owned by them, would automatically vest in a trustee in bankruptcy. That trustee in bankruptcy would realise all of their assets, including their home, so as to meet all of their debts as far as possible, including both personal and business debts. And just to add that bankruptcy is an extremely expensive way of paying one's debts because of the costs that are payable to the official receiver and to the trustee in bankruptcy. Partnership, the position in relation to partnerships is very similar to that of sole traders, i.e. that all partners' assets and liabilities, both personal and business, are included within the same process. It should be noted that a creditor can pick and choose which partner they pursue for a debt, or they can pursue all of the partners. Limited company, a creditor can take action against the company, not against the individuals behind the company, provided that the debt is owed by the company and not by the individuals. Such action can include obtaining judgments against the company, ceasing to trade with the company and supply required supplies, enforcing judgments by instructing bailiffs or High Court enforcement officers to seize goods, serving a statutory demand, and in the worst case scenario, petitioning the court for the winding up of the company on a compulsory basis for the non-payment of the debt. If a company enters into compulsory liquidation, the business of the company would cease and the directors would lose their powers over the company. The official receiver and thereafter a liquidator would realise the assets and pay surplus monies after costs to the creditors. Usually there would be no liability to the individuals, i.e. the directors or shareholders. However, such is not always the case. When a company becomes insolvent, i.e. unable to pay its debts, then the director's duty to act in the best interests of the company switches to a duty to protect creditor interests. That means usually ceasing to trade and liquidating the company so as to prevent further losses to creditors. Failure to do so can render the directors personally liable to meet the debts of the company from the point at which it becomes insolvent. And for those interested, there's been a recent important case on this point, which is the case of Sequana, which was decided in the Supreme Court in 2022, which decided that there was a sliding scale, meaning that the weight given to the interests of creditors will increase as the company's financial difficulties become increasingly serious. But the important point to note here is that if a company is nearing or does become insolvent and continues to trade, then the directors potentially lose the protection of limited liability status and could be held responsible for misfeasance, fraudulent trading or wrongful trading, which would or could very well result in them having to contribute to the assets, and that contribution could be significant in amount. Also, in a liquidator has to report to the director's conduct reporting service, i.e. the government, as to the conduct of the director in the run-up to the insolvency event. And generally, this could result in the individual being disqualified as a director for a period of years if it's considered that they have acted in an inappropriate manner in respect of the affairs of the company. It's important for the business owners to understand that the problems which the business and they personally may face as a consequence of failing to heed the warning signs and thereafter failing to act. So what can be done if a business owner identifies warning signs and can see that there are issues with the business, then early action and the involvement of an insolvency practitioner can help rescue the business. Or if that's not possible, appropriate steps can be taken in respect of the closure and winding up of the business, and at the same time prevent the business owner from falling foul of any rule which would render them personally liable for the debts of the business. The steps that can be taken depend on how soon the business owner acts and seeks advice. The earlier the action, the greater the range of options. The options depend on the type of business structure. So in relation to a sole trader, the options include an informal arrangement with one or more creditors. An IP can negotiate with HMRC or other creditors on behalf of the business owner using their experience to get the best outcome. And the creditor will often see that or consider that the business owner is acting responsibly by appointing an IP, and will also understand from the contact from an IP that insolvency is a distinct possibility. Individual voluntary arrangement. This is a statutory alternative to bankruptcy, where an insolvency practitioner assists a person in presenting a proposal to their creditors. If accepted by at least 75% in value of creditors, all creditors are bound. Usually, a business will offer to make contributions on a monthly basis over a number of years to pay existing debts in full or in part, and in full and final satisfaction. Debt relief order. These are not usually available to business owners as there are strict criteria. They're more of a remedy for individuals and consumer debt. A person must owe less than £30,000 and have assets of no more than £2,000. So the criteria is tight. If eligible, at the end of the DRO period, which is usually 12 months, the debts are written off in full. Bankruptcy, a person can apply for their own bankruptcy or may be made bankrupt by a creditor, such as a final solution to the person's financial difficulties. However, personal assets, including the bankrupt's home, if owned, are included as assets which a trustee in bankruptcy would realise, i.e. sell in order to meet all of the person's debts, both personal and business. And as stated before, it's an expensive process. Moving on to partnership, more or less the same position as a sole trader. However, matters are more complicated due to the relationship between the partners. Each partner can present an IVA, an individual voluntary arrangement, in respect of their own personal positions, or if possible, it is possible for interlocking IVAs to be made by the partners as a collective. In relation to limited companies, the options are as follows. As with an individual, there can be informal arrangements with one or more creditors. An IP can negotiate with creditors on behalf of the company, again using their experience to get the best outcome. And again, creditors will see that directors are acting responsibly, and that insolvency is a distinct possibility. A time to pay arrangement can be reached with HMRC, and an IP can negotiate with HMRC on behalf of the company using his or her experience to attempt to reach an arrangement with HMRC for the debt to be paid over a period of time. A moratorium can be obtained, a moratorium being a period during which creditors cannot take action against the company without the court's permission. Under the Corporate Insolvency and Governance Act of 2020, allowing the company time to pursue or a rescue or restructuring plan. In practice, these have not been particularly common. Administration, this involves the appointment of an insolvency practitioner as administrator of the company, and creates a moratorium during which time the administrator works to try and rescue the business, sell the business as going concern, or if such is not possible, to liquidate the business. A CVA, a company voluntary arrangements, this is the corporate version of an IVA. This is a statutory alternative to liquidation, where an insolvency practitioner assists a company in presenting a proposal to its creditors. If accepted, again, by at least 75% in value of creditors, all creditors are bound. Usually a company will offer to make contributions over a number of years, again on a monthly basis, to pay the existing debts in full or in part, in full and final satisfaction. Voluntary liquidation, CVL, creditors voluntary liquidation. This is an out-of-court process where the company appoints a liquidator. Usually it's the IP that they've sought advice from to liquidate the company, i.e. to bring an end to the company, providing for the orderly disposal of the company's assets and following payment of costs to distribution to the company's creditors to finalise the debt position. Moving on to and concluding with some final tips, some do's and don'ts. Firstly, do know your business thoroughly. Don't leave it solely to your accountant or bookkeeper to be the only person who understands the financial circumstances of the business. Secondly, do have paper or electronic systems and documents available to you, and understand them. Such documents as referred to before: cash flow forecasts, aged debtor reports, bank reconciliations, sales forecasts. These documents can be daunting at first, however, they're usually straightforward in nature and can give the business owner a real insight into the financial health of the business. If you don't understand them, ask your accountant or bookkeeper or whoever has prepared them to explain them to you. 3, don't ignore or delay dealing with letters of demand from creditors, suppliers, emails, telephone calls, county court claims, judgments, bailiffs, HMRC, or statutory demands. If you receive them, deal with them and deal with them early. 4, don't put your head in the sand. The problems will not go away. They'll only become worse. Working harder and or focusing on areas of the business which are going well will not resolve the problems which have arisen in other areas. Tackle those problems first. 5, don't embark upon reckless or wild strategies to save the business. Rolling the dice with a risky business strategy may make matters worse for you and for the business. 6, don't sell or dispose of assets for less than market value or otherwise than in the ordinary course of business, as you could become personally liable for any loss to the business, and the transaction may ultimately be undone by an appointed insolvency practitioner in any event. Don't resign. 7, don't resign as a director. If you do, you'll lose control of the company, and such would be regarded as a negative act should the business enter into an insolvency process. 8, don't delay. Don't let the molehill become a mountain. Very often people tell me they wish they'd come to see me several months earlier, and it would have saved them a long period of anxiety, and matters could have been resolved much sooner. And finally, number 9, do seek advice from an insolvency practitioner as soon as possible. The sooner you do so, the more options will be potentially available to you, and the more options and avenues there will be to be able to rescue the business. If rescue is not possible, then early advice could prevent you from incurring personal responsibility. And that's pretty much it in relation to the talk.
That's great. Thank you, Patrick. It's a difficult subject, but sort of, I guess my takeaway is that it's more difficult the longer you leave it. And I guess in many cases, by the time people come to you and the work lands on your desk, it would have been a whole lot easier if people had come to you weeks or months earlier than they have. That's sort of my takeaway. You said don't bury your head in the sand or kick the can down the road, whichever term you want to use. But that's kind of my takeaway, really.
Yeah, it's as we know, it's human nature, both in our personal everyday lives and that continues on in business as well. It's highly understandable. It's certainly not. I'm not here to criticise anybody for doing so, but people put a lot of energy and effort into their businesses, trying to make them work, and to allow them to fail just because they've delayed, taking advice which could help them, is a real shame. And the main point is don't ignore the warning signs. Deal with it, and there are plenty of people like me out there to be able to give advice and help.
Yeah, I think one of the other things as well is it's not necessarily, and probably very often, not the direct fault of the business owner. It's not a failing of their part. One of your early slides was sort of listing all the external factors that are going on at the moment: so cost of living crisis, war in Ukraine, COVID, financial crisis. There's lots of things out there. So you needn't consider it as a failing of yourself as an individual, as a business owner, that this has come about. No,
absolutely. It's as I said at the start, it's an extremely difficult time to be in business. It's about negotiating the difficulties that are being thrown up on a daily and weekly basis. It's not the business owner's fault. They're doing their best. They're trying to run their business. They're trying to make a good go of things. But those things are out there, and it is difficult, and they will potentially destroy a very good business, despite the best efforts and best intentions of a good business owner.
Yeah. One of the things, we run a series of business grants, and one of the requirements of that is that they produce cash flow forecast and a business plan with all of our grants. And it's kind of brought home to me that the reason that we ask that is not because it's fun for them to do or anything like that, but just maintaining that cash flow forecast and indeed your business plan is just a useful way of you keeping on top of what's going on within your business, making sure that you're aware of all aspects of it. So whilst we ask for it as a requirement of our business grant process, there is sort of an underlying reason why businesses should have those documents in place and up to date at any given time anyway.
Yes, they're tools, aren't they? They're tools that are useful to the business owner, just to keep to have an initial understanding of the business, but also to keep regularly in touch with the financial health of the business. And there is a temptation to leave it to the accountants. They are the experts with numbers and with accounts. But as I said, it helps if you also have a grip on the financial position of the company. How much are we selling, how much are we getting in, what's our profit level. It's all stuff that anyone can understand. As I said, these I'm not an accountant. I'm a lawyer, and sometimes I look at accounts and financial documents, and I'm daunted by looking at them. But if spending a bit of time looking at them can really help, and if I don't understand something, once somebody explains it, I see it. So that's something I would say to people: if you don't understand a document that somebody else has prepared, ask them to explain it to you, and you will understand it once that's been done.
Yeah, absolutely. I think the other thing is it's just be prepared to ask for help, and don't be worried about that. I mean, we've got a range of business support organisations that we work alongside, not least of all Business Wales. They have one-to-one advisors that can come in and talk to you about your business, help you review your business plan. So that help is out there, and sort of one of the key roles that Steve and I have undertaken, and one of the key points of the Business Swansea service, is just making sure that businesses access that support that's available to them, usually free of charge. But it's just being prepared and being aware of the access and making sure that you engage with it as business owners, because it's out there. Use it.
Absolutely, yeah. That's add it to your armory, you know, part of your business to have a list of people you can go to help, because as you say, it's out there, it's available, and why not use it? It's an excellent resource, and it could save your business. Yeah.
Absolutely, yeah. Anything from your side, Steve?
Yeah, I got a few questions on that particular point, Patrick. I put on here about obviously there's the Citizens Advice Bureau for the general public, isn't there? And obviously we know about Business Wales, etc. Obviously getting an insolvency practitioner in before you start hitting these issues, or you're on the cusp of, is good practice. But obviously there's probably charges related to that. So is there anything that you know of as a good organisation preemptive, even before you guys get involved, that can provide a service for free?
Well, on that point, it's you know, for us personally, me personally, it's on our stated on our website. You know, we offer free consultations.
Oh, right, okay.
We offer free consultations, whether that's half an hour or an hour. Just to sit down with people who have financial difficulties with their business. And if it's the case that some action needs to be taken, which would trigger a cost, then obviously we'll explain the cost to them, and we will identify how that cost might be paid, whether it's from the business or from a third party. But the initial advice is free of charge from us. Yeah.
The other thing I want to ask you as well was a bit about I think one difficult, especially for businesses that have got employees, okay, is around sort of transparency, and it must be a very delicate matter when you obviously have employees and your business is potentially hitting some financial troubles, and there's obviously trying to be it's good practice to be transparent with your staff, of course. But then also there's potential issues, especially if you're within a small community or so on, with regards to confidence within the business locally amongst local suppliers, etc. Any sort of general advice around that? Because it's quite it's always seemed to me that that must be a very difficult line to tread.
Yes, I think that's exactly right. It is a very difficult line to tread. You know, these the employees are important, if not vital, to the business. It's their livelihoods, and it's their incomes and you know their ways of financing and funding their lives and so on. So it's very important to employees, any decisions that the business owners might take. Having said that, the responsibility for the business is with the business owners, the directors of the company. And so usually initially the business owners would meet with someone like myself away from the business premises, and that's not with a view to hiding anything from the employees, but you wouldn't want to alarm the employees unnecessarily. And of course, no decision has been taken as to what will happen in relation to the business. And so initially it would be kept private, not to be the employees, but kept private, so that the business owners can make the best decision possible. But there comes a point when if the company is going to enter into an insolvency process, the employees have to be told. And we offer to inform the employees if that's what the business owners wishes to do, and we explain to the employees the reason for the insolvency of the company, perhaps, and that it's beyond the, you know, going back to your point, Matt, you know, this is not something that the business owners want or have chosen, but it's a matter of circumstance. But then we go on to advise or to explain to the employees what their rights are and what will happen in relation to them. We don't sort of cut them adrift and let them fend for themselves. So we do assist the employees as well.
Another other interesting one I sort of picked up as well was, I suppose you probably see this quite a bit yourself, and you did put it in your slides about, um, you've probably come across some businesses that have been affected by a company going into liquidation as a creditor, and that then obviously puts them into jeopardy. So, for example, if they're supplying a business, of large value items, supplies, sums, whatever it is, you know, what sort of safe, I suppose you'd advise those companies about looking out for the early signs perhaps, and putting in some safeguards with regards to, when you are, potentially being a creditor, and where's the point where you need to take action yourself to basically safeguard your own business. I bet you probably see a lot of that.
Yeah, we do, and we see people come to us who've, and again, this is not a criticism. This is just an observation about things. They've put all of their eggs in one basket because they've been dealing with one particular party, and that party itself has had financial difficulties and hasn't paid them, and that's put put them in financial difficulties. It's difficult because, on the one hand, what we say, don't allow the period to go too long. Do chase the debt, make sure it's paid as soon as possible. It can be done it doesn't have to be done in a hostile way. Phone calls, letters, chase up debts, look after your business, make sure that you get paid for the valuable services and goods that you've provided, and that you paid on time. Sometimes it slides, and it slides just because the business owner is doing other things, or has focus on other matters. But keep an eye on it and try and chase it up, and be robust really about collecting in debts and invoices for which you've provided good value in terms of goods and services. Yeah.
And I suppose one of the key things as well is ignorance doesn't remove you from liability, does it? I mean, that's one of the key things is, like you said, if you're using an accountant, bookkeepers, employees, etc., it's vitally important that you've got a good handle on the business, because at the end of the day, you're the person that's responsible and liable. And I'm sure you see a lot of this with regards to some companies where an employee is, their role is to cover a particular area, say for example finances, and perhaps the business owner say, well, I wasn't aware, etc. I suppose your big advice from today is, be aware, get involved, and keep a good handle on it, because you are the person liable, and it's not a valid excuse, is it?
No, it's not. The stepping up and becoming a director shouldn't be taken lightly. It comes with significant responsibilities and potential liabilities as well, and it won't be sufficient if a director ends up being criticised, or a claim is made against them for wrongful trading, or some form of misfeasance. It won't be sufficient for them to point the finger at somebody else. It will be said, well, you are or were a director, and so the buck stops with you. There is a saying, isn't there, that you can delegate the task but not the responsibility. So if you're a director, as much as you can, and I know it's difficult because you people are doing various things within businesses, but as much as you can, be hands-on, and make time on a regular basis, whether it's weekly, bi-weekly, monthly, quarterly, to get to grips with the financial position of your company. We do see people who come in to see us and say, I had no idea. I didn't know we owed this. I didn't know we hadn't collected this debt in. I didn't know that our sales had dropped off. I didn't know this. I didn't know that. And it's entirely understandable, but it doesn't help them. So a big point is get to grips with your business and understand it as best you can.
Great. Thanks, Patrick. That's been great. Thank you.
Good. Yeah, thank you, Patrick. We've covered a lot of ground there, but all of it is really important. And just to underline that message, act early and, you know, prevent the worst case scenario, I guess. So contact details are on the screen now. Thanks again for your time, Patrick. We'll wrap it up and leave it there. But presumably anyone can get in contact with you via the details on the screen for that initial consultation as required.
Yeah, absolutely. As I said, you know, we offer an initial free consultation. It's available there for people to use if they think they're having financial difficulties. We'd rather that than them come and see us 12 months later with real problems. So yeah, thank you both for your time this morning.
Great, thank you. Many thanks to Patrick for providing a really useful overview of the subject matter in that video. As always, please take time to look back through the ever-growing library of content on this YouTube channel. There's a wide range of business topics, many of which I'm sure you're going to find very helpful in running your own businesses. Also, do take time to make sure that you're signed up for our business e-newsletter. Our business e-news contains details of news, events, and indeed funding opportunities coming up for your business. Details of how you can sign up for this are in the description for this video. So once again, many thanks for watching and see you in the next one.